Welcome to Patent Trademark Blog. This is patent and trademark attorney Vic Lin. Thanks for joining us. In this video, we're going to be talking about provisional patent applications. We're going to talk about the basics of what you must know and some of the mistakes that you want to avoid when you decide to file a provisional patent application. We're not going to get into the mechanics of how to file a provisional and all the details and formalities. This is more of a big picture overview of the significance of a provisional and the purpose of a provisional patent application. And I think that's really important for you to understand because you don't want to get lost in the weeds of all the technical details of submitting a provisional that you overlook the most important thing, which is, well, does your provisional patent application sufficiently cover your invention? Does it accomplish the goal that you set out to do when you filed a provisional patent application? And that goal is to support your later non-provisional utility patent application. That is the point of a PPA. So let's dive in. So what is a provisional patent application or a PPA? It is a type of utility patent filing as opposed to a design patent. There's no reason to file a provisional if you want to get a design patent. You should just go ahead and just file that design patent application off the bat. Design patent application is going to have drawings, it's going to have figures that show the ornamental appearance of your product or your concept. So there's no need for a provisional for that. If you file a provisional, what you're doing is you're starting the journey to get a utility patent. Okay. Here's an outline of what we're going to be talking about today. So we just cover that first point. It is a type of utility patent filing. Now, a provisional patent application is a temporary placeholder. It gives you a 1-year patent pending status. And what do we mean by that? Well, that means that by the end of that 1-year term, 12 months from the filing date of your provisional patent application, you must follow through and file a non-provisional utility patent application in order to get the benefit of that earlier provisional filing date. So let's take a quick example. Let's say, and I didn't put a year here, let's just assume that we're talking about the same year. So it could be this current year. Let's say on January 3rd of this year, you filed a provisional patent application, and in that PPA, you disclosed how you have a device, and that device has features A, B, and C. Now, let's say by the end of that same year, on December 29th of that same year, you file a non-provisional patent application, and that non-provisional patent application claims priority to your earlier January 3rd PPA. Okay, so you filed your non-provisional within 12 months. That's good. Now, in this non-provisional application, let's say that you talk about how your device has features A, B, C, and D. So in other words, D is a new feature that you added to the non-provisional that was not included in your provisional patent app. How does that affect anything? Well, in your non-provisional utility patent application, you're going to have claims there. And you don't necessarily need to have claims in your PPA, but you must have claims written properly in your non-provisional application, and those claims will define the scope of the legal rights that you're trying to get with that utility patent. So let's say you have claim 1 where you say, I claim a device that has features A, B, and C in it, and then you have claim 2 where it says, I claim a device having features A, B, C, and D. What ends up happening in this hypothetical is that your claim 1, which comprises A, B, and C, will get the benefit of that earlier provisional filing date of January 3rd because A, B, and C were disclosed in that PPA. But now in claim 2, which comprises A, B, C, D, what ends up happening here is that you have a later priority date of December 29th for claim 2 that recites A, B, C, D, and that is because support for D is found in the later December 29th non-provisional patent application. So what this is hopefully illustrates for you is that it is very important. It is absolutely critical that your provisional patent application discloses all the key details of your invention that you might want to claim later when you file that non-provisional. If you have to add features or new subject matter to a later filing, such as adding D here in this later non-provisional, then any claims that recite that later feature will have a later priority date. And a later priority date means that prior art, prior patents, literature, just pre-existing public knowledge out there, if the examiner can find A, B, C, D with a date earlier than December 29th, they're going to use that prior art to reject your claim too. So having a later priority date is a disadvantage because then that means the examiner can find any prior art earlier than your December 29th filing date and then use that to reject those claims. Now, had your provisional patent application disclosed A, B, C, and D, then guess what? Claim 2 would have gotten the benefit of that January 3rd, that earlier priority date of the provisional. And having that earlier priority date might then precede some of the potential prior art references that the examiner could have used to reject your claim. So that is the whole point. In terms of what should be included in a provisional patent application, the USPTO has a pretty helpful webpage here. If you're wanting to just do some of your own research, whether you're going to write it yourself or you're going to have a professional write it for you, there's a lot of information by the USPTO where it talks about what a provisional ought to have, some of the cautions, things to be careful about. Typically, you're going to have text and drawings. Those are the two most important parts of your PPA. And in terms of what those text and drawings should cover, well, they need to cover those core features of your application that you're going to want to claim. So it's not so critical to talk about the common or the parts of your product that are already known or already in the prior art. You really want to focus the bulk of your description and your drawings on the unique features, really expand upon those key features, go into gory detail about the structure and how it works and how those unique features makes your product different than what is already known in the past. So let's talk a little bit about if you're going to hire a professional, how much should you pay for a provisional patent application? I think one way to think about this is to work backwards from the cost of a full non-provisional patent application. So I have an article here talking about what's the sweet spot for the cost of a provisional patent application. If you have a more complicated technology, the non-provisional, the full-blown utility application is going to cost more, obviously, than a simpler one. So if you work backwards from the cost of a non-provisional, let's say you get a quote for what a non-provisional should cost, or at least have some ballpark idea, then you could kind of work backwards from that. And one thought would be to pay about 50% of the cost of a non-provisional application. And why 50%? Well, 50% of the cost of a non-provisional application should be sufficient to give you a pretty detailed description and drawings of your core invention. Your provisional patent application does not need to include the formal claims that your non-provisional would. So you can defer some of that effort and that cost of drafting the claims when a provisional is being drafted. You're focusing more on just writing up the invention, showing it in the figures, and just making sure that you have adequately covered the key features. You leave the claiming later to, when you're ready to file the non-provisional. So a 50% cost of a non-provisional should be sufficient to get you a decent in provisional application. That's just one thought. You could do less than that. You could pay less than 50% of a non-provisional cost, but just keep in mind that it's a sliding scale. As you pay less and less for a provisional, you will generally get less detail. You're generally going to get less labor, less effort for what the patent practitioner is going to put in your provisional. And if you have less details in your provisional, you have a higher risk that later on in your non-provisional, as you start including claims that talking about A, B, C, D, or A, B, C, D, E, and F, there's a higher risk that a cheap provisional is going to leave out the support that you need for the features that you want to claim in your non-provisional. So it's a general rule of thumb, and there's always going to be exceptions to the rule, but generally, the less you pay, the less detail you'll have in the provisional, the higher the risk that you're going to end up with a later priority date, and therefore the higher the risk that these claims are going to get rejected because you don't have an earlier priority date for the features that you want to claim. And that's ultimately the biggest risk of doing a provisional patent application yourself is, do you feel confident that you have adequately disclosed the core features of your invention? Have you covered all the core features, and have you described and shown those core features in adequate detail so that they support the claims that you'll later want to pursue in the subsequent non-provisional patent application? And if you've never written a patent application before, it's hard to tell if sufficient details have been provided. That's the thing about doing it yourself. And one of the cruel realities of finding out that your provisional patent application might be deficient is that you cannot travel back in time. So let's say you file your provisional January 3rd earlier of this year, and then later on you file, at the end of the year, you file your non-provisional. Well, you're not going to get that first review of your non-provisional application until about 16 months after your non-provisional filing date. Now, right here from the USPTO, the pendency of a non-provisional application on average is about 16 months from the filing date of your non-provisional. And so going back to our little hypothetical here, 16 months after December 29th is when, on average, you might get that first office action. That office action is a letter from the patent examiner containing their summary of the review, and it will typically have claim rejections, or if any claims are allowable, the letter will say which claims are allowable, which claims are rejected. In most cases, that first office action will have claim rejections. I think over 90% of utility non-provisional applications will get at least a first office action with claim rejections. That's 16 months after your December 29th non-provisional filing date, which is, in this hypothetical, about 27 months from your January 3rd provisional patent app. So imagine that. Over 2 years after you file your provisional, it's going to be the first time you hear from an examiner as to certain defects that may have been in your provisional that you wish you could correct. And so one of the feelings that I really want to avoid for myself and I want to avoid for my clients is that feeling of regret. Like, oh, I wish I could go back in time and do something differently. And that's the problem with a defective provisional or a deficient provisional patent application. You cannot travel back in time to January 3rd to add more stuff to that provisional. You are locked in to whatever content was included in your PPA as of that date. You could always try to add more features when you file a subsequent patent application in this family, but you can't go back to that first PPA to add more to what was missing as of that date. And that's the cruel reality, is that a lot of folks don't realize that they have a deficient PPA, and they won't find out until years later that their PPA was deficient and there's nothing they could do about it to go back in time. So I hope this video was helpful for you, and thanks for watching, and I hope to see you in the next video.